Welcome to Senior PrimeTime, where real people and real conversations come together. Hi, I'm Bonnie Keith, creative visual director, industry veteran, and your host of Senior PrimeTime. This podcast is brought to you by the Foundation for Senior Services, and I'm joined today by its co-founder and CEO, Joyce Robertson. Senior PrimeTime brings you conversations with certified specialists and trusted partners of the Foundation, focused on the topics that matter most to seniors. Today, in episode 5, we are tackling the often confusing world of estate planning in an eye-opening conversation with Daniel Van Slyke, attorney at law. We'll cut through the legal jargon and talk about how planning ahead can help protect your family, your legacy, and your peace of mind before a crisis happens. But before we begin, we want to give a special thank you to today's episode sponsor, Lily Schweitzer Wealth Management. You'll get personalized financial planning, investment management, and retirement strategies built just for you. And with that, let's get started. Welcome, Joyce Robertson and Daniel Van Slyke. It's wonderful to have you both with us today. So let's get right into it. Daniel, what inspired you to focus your legal practice on estate planning?
When I started my legal practice, I was in the litigation department of a firm in Dallas, Fort Worth. So I'm licensed in Dallas, that is Texas, to practice law as well as in California. And I wound up with what they called the dead person files. So if there was anybody dead, they gave me the file. So dead people have a bad habit of not paying their bills, especially if they didn't plan ahead. And so I wound up with a huge caseload of basically files involving lawsuits because somebody had died and debts weren't being paid, and over 400 of those. So that, after doing all that litigation, and I didn't mind it at all. I kind of enjoyed it because I would step into these situations where there were family members who had no idea what was going on, didn't understand the probate system. A lot of that litigation was in probate courts. And I found that I could actually explain it to them, make them feel a lot better, even though I wasn't necessarily representing their interests. I would tell them that when I spoke with them, whose interests I was representing. But then I would explain to them what's going on and where they are in the process and what to expect. So I found that I really enjoyed working with the families. I also found that I had developed an incredible knowledge of what happens when things go wrong and how many ways there are to fail to plan. Because as we say in estate planning, failure to plan is planning to fail, because your estate will be a mess. Somebody, unless all you have is a little, cart full of stuff that you're pushing around the streets of LA, somebody's going to have to come and clean up your mess at some point. And so I really decided that I would serve people better by helping them to avoid the whole probate process. And so I made a very deliberate shift, and it coincided with a move to California. So I made a very deliberate shift from Texas to California, and from probate litigation to the estate planning side of things, because I much prefer to help people avoid trouble. And I feel better about that. And I give more value, to be honest with you, doing that. Because the expense of an estate plan is a fraction of the expense of a probate proceeding.
Got it. So what happens if people either don't have an estate plan, or they become incapacitated, or they pass away? Why do people need an estate plan?
Yes, those are great questions. So the biggest mistake, I think you kind of answered your own question. It's not planning. And doing no planning is pretty much a guarantee that you're going to have trouble when you're gone. So even those pesky little bank accounts, you think, well, there's not much money in them, et cetera. I can't tell you the number of times I've had calls from people and they've told me, mom or dad who's gone now had this bank account, or maybe they had a business and the business had a little bank account. We need to access those funds. Maybe there's 15,000, maybe there's 20,000. And the bank is saying, we're not even going to give you information about the accounts. And the banks are very tight about information. And I know some people say there's this thing called a small estate affidavit, which is supposed to work. That doesn't mean that the banks will necessarily accept it, or that you'll even know about the bank accounts. So, a lot of times somebody dies, you don't even know where their money is. So even those little bank accounts, people will sometimes come to me and I'll have to explain to them that it just might be more expensive to go to the court and get an order allowing you to access that account than the value of the account itself.
So,
So
so
you might be leaving money on the table, in which case what happens, it sits in the bank for a couple of years and the bank gives it over to the estate. They're unclaimed funds, and then eventually it goes to the state.
then I have a question. Can't you designate with the banks a beneficiary where it doesn't have to go into a trust, and then they can access it because their names are basically on the bank accounts?
Yes, you can. You can do that with some types of accounts. Not every type of account allows payable on death beneficiary designation. And that's what you call extra probate. In other words, if an account has a beneficiary, then it goes according to the beneficiary designation with the bank. It doesn't have to go through probate. So those extra probate transfers can be nice. So, but again, not every bank account allows that. So it's very particular kinds of bank accounts. They'll be called something like TOD or POD. So the TOD is transferable on death or transfer on death, and the POD is payable on death. So if you have a TOD or POD, it'll work great when you're dead. Now, when I'm estate planning, I'm not just planning for when you're dead, because there may be a period. And as a matter of fact, if you live over 50 years, you very likely will go through a period, which may be a lengthy period, where you are here, but you're not able to manage your affairs.
Right.
So the payable on death or the transferable on death, again, they're great if all you're worried about is somebody having an easy time when you die. But if you're going to go through a period of incapacity, that doesn't help you at all. So the people that you would like to be helping you can't necessarily access those accounts, even if they're the beneficiaries of the accounts when you die.
Got it.
That's the shortcoming of the POD. But for probate avoidance, it's going to help you avoid probate. But do keep in mind that a conservatorship is a type of probate. So what's a conservatorship? That's that's when you're incapacitated and somebody needs to take care of you. Somebody needs to take care of your assets and pay your bills. Just pay your bills. And nobody has that authority. Or people are fighting over who gets to do it. So then that goes to the probate court too. That's called a conservatorship or sometimes a guardianship. There are technical differences, but different states use them differently.
And isn't that why you have power of attorney? So can you explain the different parts of what a trust does to help protect you in times of both incapacity and eventually, you passing?
Yeah, powers of attorney can help with that too. So powers of attorney are for, and when I do an estate plan, I will include powers of attorney. Now, what's a power of attorney? That is a document that only works while you're alive. Okay, so payable on death is only useful when you're dead. The power of attorney is only useful when you're alive. So with the power of attorney, you designate somebody to be able to manage your assets in general if you're here but incapacitated. They can be used for other purposes too. Say you're traveling in Europe, but you're trying to buy a property in the United States. That's another place where you might use a power of attorney. But in estate planning, we generally have a power of attorney that kicks in and becomes effective when you are incapacitated. And now, why do I include that with a trust? Because there are some assets that don't go in trusts. For example, your retirement plans. Any retirement plan that falls under this federal law called ERISA, which is all about retirement plans, is going to be transferable into a trust. So that includes your 401k, most people's IRAs, things of that nature. A trust can't own them. Power of attorney can allow the person that you trust to manage those assets while you're here, but you're not able to manage them yourself. Social Security is another thing. You don't really put your Social Security benefits into a trust, but what if somebody needs to talk to Social Security on your behalf? Again, powers of attorney would kick in there.
Then I want to get into wills, because that's a whole other confusing thing. Like, well, I have a will. Why do I need a trust? Or I wrote down a thing I hear some people writing like sticky notes and sticking it in their underwear drawer, and what's all that?
Sticky notes are they're great for estate planning. I've seen it, and
oh no,
yeah, it's like grandma goes around the house and she puts on this piece of furniture and that jewelry. It's like this goes to Todd and this goes to Sue.
No way.
Yeah, people have done it, and then the problem with that, of course, is the first person in there can just like, oh wait, say Todd enters first. I'm going to switch these. I don't. Or, they fall off, or the house, or worse yet, grandma didn't plan for the house. And by the time anybody gains access to it, it's just a big mess. So,
Wow.
but let's back up and talk about the other documents of your complete. Does anybody remember those cereal commercials? Like, this is part of your complete and nutritious breakfast. Frosted coated sugar bombs, and then they're complete and nutritious when you have like eggs and milk and fruit with them, I guess. So a complete and beneficial estate plan will also include your healthcare documents. What are those? A healthcare power of attorney or an advanced healthcare directive in California will allow you to name somebody to take make decisions for your care in the event that you're unable to do so.
Right.
And that could happen at any time. If you go in for surgery, if you're in an accident, whatever, you really should have these. Even when your kid turns 18, to be honest with you, you should have those for your child, because once they're 18, you don't presumptively have the right to make any decisions for them. So I advise that even for when you have a child that's just turned of age. So what do? You can name in there as well, not just who you trust to make the decisions, because maybe one kid just wants to pull the plug and get his inheritance, but the other actually cares about you. And I see this, by the way, in estate planning. So you obviously don't want the one that just wants to pull the plug and get the inheritance to make your healthcare decisions.
Correct.
Have an equal share in that. I mean, maybe you do, but most likely you don't. The healthcare directive makes sure that the one that you trust to make the right decisions for the right reasons is the one who actually is empowered to make those decisions. The hospitals love those. The doctors love those. Everybody loves those. So I always make that part of the estate plan. I walk you through some of the options you have in the form that the state gives you, and then you give them to your doctor. Let's say you belong to Kaiser or something like that. They're all scanned into your system, and they'll be everybody who is working on your healthcare will be able to see that you've named certain people to make those decisions. So the healthcare documents are important. And again, that's while you're alive, but you're not well, because you don't want to have like a Terry Schiavo instance where people are fighting in the courts over who gets to make the decision for you. You can decide that. And then the will. Now let's get to the will.
Do you need a will if you have a trust?
Do you need one? I prepare one as a backup.
Okay.
And why, you might ask? Because the trust only controls what's in the trust. So let's say you go to Vegas, you've got this beautiful trust. Everything is in the trust, your home, your bank accounts. You've set it up perfectly. So the person that you really know and trust is going to be in charge of things. You're going to leave it to your beneficiaries in the best way possible. You've really thought this through and planned it out. You go to Vegas and you win $1 million and you die of a heart attack. So what happens to your $1 million? Well, guess what? You never put those in the trust. So you have $1 million that didn't get put in the trust. Now, what happens if you don't have a will? I mean, either way, the $1 million is going to go to probate, and a probate court decides what happens to it. Without a will, it's going to be intestacy, which means the state law and the judge decide who gets that money and who gets to be in charge of it in the whole 9 yards. So you avoid that possibility when you have what I call a pour over will. So the pour over will goes with the trust. It says that if there's something that should have been in the trust but didn't get put in the trust, I want to put it into the trust. So it's a backup. So if you wind up with that, winning that lottery and then dying of a heart attack, it'll get the money in the trust so it goes the way you want it instead of by intestacy. So remember that complete nutritious estate plan. It's going to include a will and a trust. And the will is a pour over or backup.
Pour over. I've heard that. I didn't understand exactly what it meant.
Yeah, it's like you have a glass, you have another glass, because I have coffee in one hand and water in the other all day long. So what you do is, let's say here's your $1 million that you won in the lotto, but it never got put in your trust, which is where everything should be. So then what you're going to do is you're going to pour that into the trust. That's why we call it a pour over will. You don't want that. I mean, that's not ideal, because then you've got a probate proceeding and the $1 million goes through probate.
So even with the will, something's in the will, it goes to probate.
Yes. And many people don't understand that. A will is just a piece of paper. I have one sitting here on my desk. It is nothing until a judge admits it to probate and appoints an executor.
Wow.
It's just a piece of paper. You can take it to the bank and they'll say, where's the court order? Nobody cares about your will until a judge admits it to probate.
Okay. And now that you keep talking probate's a big thing.
Yes.
In total plain English, so that we all understand what is probate and why.
Yep. Money, time, uncertainty, stress. So those are a few of the reasons. But what is probate?
Mm-hmm.
It is at heart, it's a court proceeding. I mean, it's a lawsuit of sorts, but you don't necessarily have a defendant, right? So, but it's a court proceeding. And in the court proceeding, the judge has to decide who is going to receive what. And the judge bases that decision upon the assets in the estate, their characterization, and the laws governing what you call intestacy in some cases. So intestacy, let's say you die without a plan. You don't even have a will. If you have a will, you're testate. If you don't have a will, you're intestate. Either way, you're going to probate court. And either way, the judge is going to decide who's in charge and what they receive. Now, if you have a good will and nobody's fighting it, then he's going to admit the will to probate, and it'll be determining what happens. But without even the will, I'll give you an instance right now. A fellow died, lived in Pasadena, had a house in his name. No estate plan, meaning no will, no children, and he wasn't married. So when you add those facts, it gets pretty complicated pretty quickly. His parents are deceased, so it might go to his parents. His parents are deceased, so then it might go to his siblings. But wait a minute, a lot of his siblings, or maybe all of his siblings are deceased. So we're still working on this, but right now we've found 27 heirs.
And where do these heirs come from? How do you find these heirs?
I mean, we do searches for, sometimes a private investigator, sometimes a genealogist, sometimes just somebody who knows how to look up databases and find names and numbers. So we found 27 so far. And now keep in mind that this property, once it's sold, it has to be distributed to all those people. I mean, nobody's really going to get much, but we call them laughing heirs because they didn't know you well enough to cry about your death, but they're going to receive a check in the mail one day. Wow. Those are the laughing heirs. Why? Because you didn't actually plan. If you had planned, you could have made it a lot easier. And the few people that really knew you and cared about it enough to contact me and ask me to do this probate, they would be having a much easier time with a lot less uncertainty. Yeah. So that's what happens when you don't plan. It goes to probate, intestacy, which is the state's laws for determining who inherits your assets when you're gone, kick in, and it can wind up being a whole lot of people that receive a very little bit of your estate.
Regarding the cost of probate, is it based on the amount of what is in the estate or what would have been in the estate?
Yes, it's based upon what's in the estate. So this is in California, it's called a statutory fee. So there's a statutory probate fee in California. And the way it works is a percentage, but it's kind of like your income tax, right? So it's tiered. So it's 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, 1% of the next 9 million, 0.5% of the next 15 million. So, and then over that, the court actually decides on the fees. Now, these are the fees. You want to keep in mind that these fees are paid both to the attorney and to the administrator. So it's the same fee that gets paid twice. So if you just have $1 million estate, which in LA means you own a modest home, somewhere not close to any really desirable area. The fee winds up being $23,000 for the attorney. And then when you have an administrator, so this one that I'm looking at, for example, the one I was just talking about, we know of a condo in Pasadena that might be worth $1 million. So that's going to be $23,000 to the attorney. That's me. $23,000 to the administrator, because you got to have an administrator that's going to get paid for this. I don't think the court would appoint any relative. So that's a total of $46,000.
Yeah, wow. Now
I could have done this guy's estate plan for a very small part of that. So he would have avoided all that. He would have had happier heirs that know what's going on. And there's a possibility also when probate is public. So how does it work? We've got to find all these people. We have to list them all. We have to list what we know about what is in his estate. And then we have to file it with the court. The court, after 3 or 4 months, the LA courts are very busy. They're very backed up. It takes at least 3 months to get a hearing. And then if they appointed administrator, then the administrator's got to start gathering assets, et cetera, et cetera. Then he has to file an inventory. So there are all these steps to go through. And the real dangerous thing is, let's say, as in this case, it's so often, there's a mortgage on the house or the condo. So let's say the mortgage is worth $1 million and you've got no estate plan. And now, again, dead people don't tend to pay their bills. So now this mortgage is going into foreclosure, and you now are racing against the clock to try to get an appointment from the probate court. So you have somebody with authority to even talk to the mortgage company and market the property for sale before all the equity is gone. So there's another thing that could happen, that home you loved and lived in for 40, 50 years could wind up being auctioned because the mortgage company, or maybe somebody else foreclosed. Maybe it was the HOA or the taxing authorities, because you've got debts that aren't being paid because nobody has authority to deal with it. Yeah. So that's the nightmare. But on the other hand, people will come to me and they'll say, well, I don't think I need an estate plan. I'll say, okay, that's fine. I'll make more money when you're dead. Come to me for probate.
Yeah.
I will now. But I feel a lot better about helping people, plan ahead than I do about doing the probates. I do the probates because if you're doing estate planning long enough, people come to you and they're like, well, you did mom's estate plan, now mom's gone. Those don't tend to be probates unless, again, something didn't get put in the trust that should have been put in the trust. But the trust administration, there is some trust administration to do, but it's not even going to be half the cost of a probate.
And you just mentioned something about stuff not being put into the trust, because you talk about that, an empty trust or funding a trust. Could you explain what that means and why a trust can actually fail if you don't do some of this stuff?
Yes. So what is a trust? A trust is a relationship where you're taking assets and you're giving them to the trustee to take care of for the reasons that you indicate. So it's kind of a relationship. So who's the trustee? The trustee, your typical revocable living trust. So mainly to avoid probate, make sure things go smoothly if you become incapacitated. That typical trust is a revocable living trust, meaning that you can change it anytime. So let's say Bonnie Keith sets up the Bonnie Keith Revocable Living Trust. There are three major roles in a trust. And you, in your revocable living trust, when you first set it up, you are in all three roles. So the first is the grantor. You're the grantor because your assets go into the trust. Second is the trustee. The trustee is in charge of things. You are the trustee because you're in charge of your revocable living trust when you first put it together. And third is the beneficiary. That's the person who benefits from the assets in the trust. And again, for you, you're everything. When you first set up your revocable living trust, you are the grantor, your assets go in, you're the trustee, you're in charge, and then you're the beneficiary, it's for your benefit. Now, there may come a day when you're still around, but you're not well enough to take care of your own assets anymore. So now somebody steps in to become your trustee. Mm-hmm. Now, the stuff that went in there is still yours. You're still the grantor. You're still the beneficiary, but now somebody else whom you trust to be in charge of your assets, if you're alive but not well, is taking care of business for you. Now, then the third phase is when you pass that point, again, you're still the grantor. So it's still your assets that went in there. You're still the always going to be the grantor. Now, you're no longer the trustee because you're gone. So the person you trust to take care of your assets is now in charge. And you're no longer the beneficiary because you're gone. So the people that you designated to be your beneficiaries now get to benefit from the assets in the trust. The grantor's assets that are controlled by the trust, though, are only the assets that the grantor puts into the trust. So when you come to me for a trust, let's say it's your first revocable living trust, you've never had one before, I'm going to ask you, what are your assets? Why do I ask that? Is it because I like to pry into people's lives? I mean, as fun as that is, that's really not the reason. The reason is because I can't help you plan for assets if I don't know about them. So I need to review everything. So I'm going to ask you about your real property. I'm going to ask you about your bank accounts. And then I'm going to tell you what needs to go in the trust. And of those things that can't go into the trust, say you have a 401k, say you have an S Corp, certain types of businesses, I'm going to advise you on how to plan for the succession of those as well. If you don't put something into the trust, though, the trust doesn't control it. So I will take care of your house. If you come to me and you have a house, I'm going to prepare a grant deed. That grant deed is basically going to say, right now you own it as Bonnie Keith, but now once you sign that grant deed and I record it with the county, you will own your home as Bonnie Keith, trustee of the Bonnie Keith Revocable Living Trust. Uh-huh. That's how you fund it. If you never do that and it's still in your own name, the trust doesn't control. That's the funding. And it has to be done for bank accounts too. You go from owning it as Bonnie Keith to owning it as Bonnie Keith, trustee of the Bonnie Keith Revocable Living Trust. That's how you fund them. No funding, the trust doesn't control. Now, sometimes people will refinance their house or they'll do something funky with their deeds. And then if they come to me to review their trust, I can catch that and I can say, your home's not in the trust. Let's get it back in the trust. But if not, let's say they die like that. Well, now their house is probably going to go to probate. In LA, it's most likely going to go to probate. There are these little rules for houses. Maybe you can have an expedited proceeding if it's worth under a certain amount. But I mean, that applies to pretty much nothing in LA unless you live in one of those tiny homes,
which is still worth something in LA. So, but even with an estate plan in place, family fights can occur. So, and strangely, like you were talking about the little sticky notes on the couch and stuff, personal items can sometimes cause bigger fights than money. This is new to me. So,
yes.
Do you have any examples of that, or like any stories?
Yeah, there are a lot of examples of that. The thing is, it's like family law. In some ways, probate is like family law. It can be very emotional. Sometimes the people involved they're not thinking in terms of economics or in terms of business. Right. They're thinking, I didn't get the little red wagon when we were 8, and that's not fair. And I've always been jealous and angry, and you've always been mom's favorite. And now you're trying to rub it in, and I'm not going to let you do that anymore. And I'm not making this up. I mean, I have heard clients report to me that they've heard similar things from their siblings. So you will have a lot of situations in which even siblings, even you grew up around the same table with these people, are giving you the hardest time possible. Here's the problem with the probate. If that happens in probate court and they contest, it's going to get really expensive really fast. It's going to slow everything down. And good luck stopping that foreclosure or something like that if it's pending, because it's just going to be really difficult to get anything done. And the price is going to add up really quickly. So now there are famous examples of this too, like Robin Williams. He had, if you look up his probate proceeding, it's one of those that kind of went on for a while. He had a pretty good estate plan, but he actually didn't account for like the things that you wouldn't think about. Really valuable, like action figure collections, and I think maybe bicycles and things like that. I mean, compared to an estate that's worth millions, it's like small potatoes. But if when you die, your wife is not the mother of any of your kids, that kind of is a sign that something might go wrong. So be sure you buttoned up everything. If you know you have a kid that really wants that Raggedy Ann doll or is emotionally attached to it, then you need to take care of that Raggedy Ann doll so you don't have them spending thousands and thousands of dollars, maybe tens of thousands of dollars in court over a Raggedy Ann doll that you couldn't get $5 for at a garage sale. And it does happen. Now, sometimes the personal property is valuable. Like you may have maybe you have a Monet hanging in your living room, and that's pretty valuable, right? And there's a lot of estate planning around fine art and things like that kind of, they fluctuate in value. In fact, they're difficult like that you can do neat tax tricks with them. But most people don't have that in their estate. What they have in their estate is little items that some people have attached, to which some people have attached very large emotional value.
Unbelievable.
Stuff in your house, by the way, is not really worth very much. I know you probably spent $20,000, $30,000 accumulating the junk in your house, but the average garage sale is going to get maybe $3,000, $4,000, $5,000.
Right.
So it's not as valuable as we think it is. I mean, once that stuff is used, you're done. Nobody really cares about it. But still, you might have people fighting over it, and you might have relatives looking on and say, I know that's worth more than that. You could have sold that for more. So you need to take care of things.
Wow. So let's say someone does have an estate plan. How often should they review it or update it? And in particular, what life changes should trigger an immediate review of an estate plan?
Yes. Marriage or divorce, that should be immediate review. Immediate review. Because once that happens, if you didn't actually plan it and prepare for it or immediately after, then the state has its idea about what's happening, and it may not be your idea. And there are some things in some places that'll go to your ex. If you still have your ex as a beneficiary, like say on a bank account or something like that, I mean, you need to revisit the whole plan, not just your trust. And that's what I do with people. So let's visit the whole plan. Another one is birth of a child. if you didn't have a child, or death of a child, that could have a big impact in your plan, depending on what the child was receiving, what roles the child was playing. And when you live long enough, your kids, they pass before you, which reminds me of this story. I don't know if you've heard it. So there's a judge, he's in the probate court, and these two people come, actually it's the family law court, 90 years old. They are 90 years old, and they come in and they want a divorce. And the family law judge looks at him and says, "You want a divorce? You've been married for 70 years. Why in the world do you want a divorce now?" And the old fellow says, "Well, we were waiting for the kids to die."
Oh my gosh.
There you go.
Oh my goodness, Daniel.
It happens. But there's a lot of emotional value over little things. There's a lot of, you really need to plan when you have mixed families. There are more and more mixed families. That's huge. And that's why when somebody comes to me, I ask them, okay, so tell me about your children. Tell me about your family. Do you have any other children? Whenever a married couple comes to me, I always ask that, It's time to come clean. Because if you don't tell me now and I don't plan for it, that person, again, if it doesn't look like you know them and you put together an estate plan not mentioning that person, then that person has certain rights under the law that you could have avoided. So I'm going to look at how to avoid the fights. That doesn't mean you can always avoid the fights, but really there's a lot of things you can anticipate in advance and you can avoid them. Like, just give the Raggedy Ann doll to the kid now. Like, why leave it in your garage so they can fight about it later if you know that one wants it, for example? Or you can actually dispose of the personal property in writing. We can determine where it goes, who gets what.
Okay.
So I really, really want to bring out the family dynamics, the relationships, who gets along well, who hates whom, things of that nature. And that will help to avoid fighting, whether you have a probate proceeding or whether you have which hopefully you won't if you planned with me and then you visited it and you've come back to update it. But yeah, getting back to the updating questions, marriage, divorce, birth of a child, death of a child. Another one is a big change in your estate. So say you sell your business for millions. You need to do some more planning. Or say you were worth millions and now you lost it all. Again, you need to do some planning because tax planning is traditionally a very important part of estate planning. It's a little less so right now because most people's estates are not going to be taxed by an estate tax. So as of 2026, you have to have more than 15 million in your estate per person before it gets federal estate tax. Most people don't have that, but let's say all of a sudden you're above that threshold or you were above it and you've gone below it. Your estate planning is going to be different because there's a lot of tax issues that go into some types of estate planning. So big increase or a big decrease in the size of your estate, that's an important thing. Another important thing is a big change in the law. So that increase, that exemption, 15 million, is a big change in the law. If you haven't had your trust reviewed in the last 10 years, or 15, I would definitely it's time because you have it like if you're a married couple, say, and your trust was done in the early 2000s, 1990s, then you probably have a trust split, which means when one of you dies, the trust splits. To make it simple, I'll say into the A trust and the B trust. So the A is the alive spouses and the B is the buried spouses. And now there are limits on what the living spouse can do with the B trust. And it files its own tax return and it can be a big pain in the butt. And if you ignore it, it can be a bigger pain in the butt down the line. So if you have not had your plan reviewed in 15 plus years, you definitely need to do it because there have been big changes in the law. And that tax planning that looked really good in the early 2000s or the late 1990s is now just a useless pain in the behind.
Wow. Interesting, Daniel.
Can you touch on the trustee and choosing your trustee? And if you don't have a family member that might be able to do that, what is a fiduciary? And tell us how that would work.
Yeah, well, that's a really good question, Joyce. I'm happy you brought that up because one of the big questions that people have when they're putting together a trust is, well, I have 3 children, right? One is, I don't know, he's on drugs and on the streets. This is more common than you might think. I've had it with a number of clients. And another is a successful lawyer, but he never talks to me and he lives in a different state. And then there's the one that lives with, next door, who should I choose? That's like the youngest one. Who do I choose? And so you have to realize that sometimes the children get jealous. They're like, why did mom choose you as trustee instead of me? And when that happens, it can cause resentment and fighting, which I'm experiencing in one of my trust administration. Again, not a trust I set up, but there is some fighting there because the siblings are very jealous. Actually, there are a couple of them that I'm working on that fall in that category, and there's really no reason for it. But I like to tell people that it's more of, if you don't get named as trustee, that's like dodging a bullet. Like you're the lucky one. Because being a trustee is a lot of work. And if you've got siblings that are harassing you, it's a lot of stress too. It can cause you a lot of consternation. When everybody gets along, that's great. Remember, not everybody gets along when somebody dies. And if they never got along, you can be guaranteed they're not going to get along when you're gone. So whatever you do, don't force siblings who hate each other to be co-trustees. That is a recipe for disaster. Also seen that. Again, I like to add, it's not a trust I planned. Those things happen for the most part. I rarely say go ahead with the co-trustees. Most of the time, if my clients do it, it's against my advice. The client decides, because it is your trust, whatever you want to do. Co-trustees, generally not a good idea. So there is an option. And in California, it's a really good, somewhat economical option, which is to appoint a professional private fiduciary. So that is a person who is licensed by the state of California to take care of business for you if you're unable to take care of business for yourself. And those people can be named as administrators in probate court. I work with some in that capacity. They can also be named as successor trustees in your trust. And I will, with some regularity, I'll put them into trusts because they're professional. They're not family members, so they're not going to get emotionally involved. They're going to follow your instructions. They're going to dot the I's, cross the T's, file the tax returns, make sure everything gets well done the way it should be. And there's just not going to be the same. You're not going to have the emotional reaction, far less fraud. When you look at all the cases that go to court, now remember, trusts and go to court when something goes wrong, right? People are fighting. So when you look at a lot of these cases, it's somebody's accusing somebody else of mismanaging the trust, of stealing money from the trust, things like that. It's always family members. There's one instance I know of where there were some shady things going on with a fiduciary. But for the most part, fiduciaries don't want to lose their license, right? I mean, that's their livelihood. They have to go through constant training. They're reputation based. If I hear a trustee has cheated somebody, I'm not going to recommend that trustee to anybody. I'm going to work with ones I know that they know what they're doing. They're very cooperative. They're very easy to work with. So trustees are a great option that you have here in California. They're not in every state. There are a few other states that have licensed professional fiduciaries like that. In every state, a bank can serve. Some people used to name banks. A lot of people are not happy with that arrangement because the banks are even more careful about dotting the I's and crossing the T's. Everything is going to take a while. It'll all be done well. But the other thing is the banks are going to require a minimum amount in your state. So for a lot of banks, it'll be like 5 million, 8 million, 9 million, whatever. If you don't have that much, and sometimes it's liquid assets. So in other words, bank accounts, brokerage accounts, things like that. If maybe you have 9 million in real property, they don't want to deal with that. So the banks, and their fees might be a little higher. Their fees will almost certainly be a little higher, but banks will do a great job, be a little impersonal, only available to those with a lot of money. And then there are also professional trustee companies, which are going to be somewhere between the fiduciary and the bank when it comes to that. They're more in other states than in California. But I think the fiduciaries for the common person who needs a trust to make sure things go well in possible incapacity, and then when they die, who does not have a huge taxable estate, I think the professional private fiduciary is a really, really good option. By the way, that was not endorsed by any particular professional private fiduciary. I did not get paid for that.
What words of wisdom can you leave our listeners or viewers from everything that has been discussed today?
Well, I'll give you one word: plan. Yes, just plan. If you haven't planned, you need to plan. If you haven't looked at your plan in a while, you should relook at your plan. But you got to plan. I mean, my firm is iPlanLaw PC because I really focus on the planning. If you plan ahead, you can avoid a lot of trouble. You might be able to avoid fighting. You'll definitely make things smoother for yourself if you become incapacitated, for your loved ones when you're gone. Just plan. And again, if you've never actually prepared an estate plan, you really need to do it. Especially if you live in let's say you live in LA, you don't have an estate plan, you need an estate plan. If you have a house, you absolutely need an estate plan. Any kind of significant assets, you absolutely need an estate plan. And again, there are other things you can do, but you really want the most complete planning possible, not only to avoid the delay and the cost of the probate, but also just to make things a lot smoother, a lot clearer for your loved ones when you're gone. So plan.
Thank you, Daniel. And for those who feel overwhelmed, just contact Daniel. It's a phone call. And to get your questions answered, all of Daniel's information to contact him will be in the description and the show notes of both the podcast, the audio podcast, and any of the videos that we're doing. So easy to reach Daniel. He's a nice guy and an amazing attorney. And Daniel, I thank you so much for your time. I know how priceless that is, and for your information and for your expertise. It means the world to me that you were able to join me and Joyce today on Senior PrimeTime. And Joyce, any last words?
Well, I just thank you for listening, and know that you can come to the Foundation for Senior Services anytime. And we make sure that we have vetted, certified specialists at all levels of need. And Daniel, as well as some of our other attorneys in the organization in different service regions, are there to help you at any time. So don't hesitate to call Daniel. Don't hesitate to call the Foundation.
And again, the Foundation's information, the Foundation for Senior Services, is also in the description and the show notes everywhere.
That foundation is wonderful. Really appreciate all your work on it, Joyce and Bonnie. And thank you for having me here today. It's been a pleasure.
Fantastic. And with that, everybody, we say take care. Have a wonderful day. Contact Daniel if you need to get any information about estate planning. And with that, this is Senior PrimeTime. Catch you next time. What a fantastic conversation today. I know I have learned so much, and I hope you have as well. Thank you again to our guest, Daniel Van Slyke, attorney at law, for sharing his time, knowledge, and insight with us. Are you ready to feel confident about your financial future? Whether you're planning for retirement or growing long-term wealth, Lily Schweitzer Wealth Management is here to guide you every step of the way. You can find Lily's contact information in both the show notes and description. Thank you again, Lily, for supporting Senior PrimeTime and helping us bring trusted conversations and valuable resources to our listeners. Senior PrimeTime is brought to you by the Foundation for Senior Services. I'm Bonnie Keith, along with Joyce Robertson, and we thank you for listening. Remember, these years can be your true prime time when you have the right information, the right support, and the confidence to plan ahead. We'll see you next time on Senior PrimeTime, where real people and real conversations come together.